Hello, Michelle Kotler here, special education attorney and creator of the Parents Playbook for Special Education Success. I wanted to take a few minutes to explain to you the difference between a Section 504 plan and an IEP because I get a lot of questions about this. There's a lot of confusion about it. And frankly, even a lot of people who work in the public school system don't understand the difference between the two. If your child has a disability, they may be eligible for either a Section 504 plan or an IEP. But here's the difference. A Section 504 plan only provides accommodations to your child. Technically, the law also requires related services to be available, such as speech and language therapy, for example, under a 504 plan. But most school systems will not provide related services under a Section 504 plan, which is illegal, of course, but what do they care? The rationale for that is that they say that they cannot get reimbursed for those services the way that they can through an IEP. And they're talking about Medicaid reimbursement. Whether that's true or not, I honestly don't know, but that is what I've heard them say. So think of a Section 504 plan as an accommodations only device. So, for example, let's say you have a child who has cerebral palsy and they're unable to walk and they need to be in a wheelchair. The classic example is that they need a ramp for the wheelchair to get into the building. That would be a 504 accommodation. That's the only thing that they need. Maybe, all their classes need to be on the first floor or they need to be able to use an elevator, something like that. Cognitively, they're perfectly fine. They can handle all the schoolwork. All they need is a ramp to get into the building and to use an elevator if it's a multi-story building. Classic 504 plan example. They don't need the support and services of a special education teacher or anybody else in the building. Contrast that to an IEP, which is an individualized education program. Let's say your child has cerebral palsy, but let's say it affects other aspects of their lives and they need more than just a ramp to get into the school building. They need what's called specialized instruction. So let's say that there's some type of learning impact that's going on. Perhaps they don't just have cerebral palsy, perhaps they have cerebral palsy and also some additional cognitive limitations or a learning disability type of profile. In that situation, they would need the services of a special education teacher. So in order to be eligible for an IEP, a child must require specialized instruction. And usually that takes the form of things like modifying the standard curriculum that all the other children are completing. Teaching the child perhaps either in the regular education classroom or perhaps pulling that child out into a resource room, for example, to teach them in a small group or one-on-one setting. All these things can be done by a special education teacher. So in order to qualify for an IEP, the child must require the services of specialized instruction. If the child does not need specialized instruction, that child is not eligible for an IEP, no matter what the disability is. However, in that example, a child might qualify for a 504 plan if they need accommodations to be successful. So understanding these differences are very important. Sometimes what I've even seen is an IEP where the child really does not need any support from a special education teacher, and the team will write consult or consultation as the service. Consult between the special educator and the general educator. I have an opinion about that. I have not done the legal research, honestly, in that particular situation to know authoritatively and definitively whether that is a legitimate service under the IDEA, but I suspect that it is not because the child is not receiving any direct service from the special education teacher. If the child does not need the direct service of a special education teacher, then that child is not eligible for an IEP. Now, the problem with this is that it's become increasingly much more difficult to enforce 504 plans because, as I stated in another video recently, the federal government has been essentially eliminated as far as enforcement goes for 504 plans, as well as ADA violations, Americans with Disabilities Act violations, which leaves only a private right of action, which means your ability to hire a lawyer and take the school system to court for failing to provide these accommodations under 504 or ADA. Very lengthy, very expensive, not a good option. The alternative is to have your child placed on an IEP. But again, you need to be able to show that there's educational impact from the disability to the extent that your child requires the services of a special education teacher. You must show that in order to get your child on an IEP, which right now in 2025, almost 2026, this is December 19th, so 2026 is right around the corner. Really, an IEP is going to be the only way to go. If you want a document that you can reasonably try to enforce yourself through the due process system that does not require an attorney to conduct. So I hope this has been helpful. Again, the distinctions between a 504 plan and an IEP are very important to understand. And if you'd like to talk with me about your child's IEP or 504 plan, or maybe your child hasn't even been found eligible yet, you have questions about special education laws in general, or you want to vent about how the school year has been going, please use my calendar link in the description and schedule a free 30-minute video call with me. I'd love to hear how things are going for your child this year. Thanks so much for watching. See you next time.